The webinar will start in about 1 minute. Thank you. Welcome, everyone. Thank you for joining us for today's webinar, Consumer Tips When Filing Mental Health Parity Insurance Appeals. Before we begin, I would like to go over a few housekeeping items. Today's presentation will be recorded, and an email containing the link will be sent to all registered participants early next week. To minimize noise and distraction, all attendees' phones have been muted, but we encourage questions and comments. These you can enter in the question box that you will find in the GoToWebinar control panel. We will do our best to address all questions and comments at the end of this presentation. Now I'd like to turn the presentation over to our moderator, Gary Carneal, who is President and CEO of Schooner Strategies. Gary?
Hi, welcome everybody, and thank you so much for joining us in this webinar today. I can't imagine a more important topic than health insurance appeals, and I'm excited about introducing our speakers today who are nationally experts on health insurance appeals, and I think you'll find the information very helpful, no matter who you are as a stakeholder, whether you're a patient or a consumer advocate or a provider or a regulator. I think you'll find the information very, very helpful. First, let me just say a few words about myself, and then I'll introduce Mary and Brian. I have a long background in kind of the health insurance space. About 25 years ago, maybe even 30 years ago, I worked for the National Association of Insurance Commissioners as legislative counsel. I was able to develop the state model regulations for utilization management and grievance procedures. So that was kind of my start. Along the way, in the 1990s, I started as president and CEO of URAC, and among other things, worked with the National Association of Independent Review Organizations to develop the first national standards for external review, which we'll hear more about. And then, for example, during my current work with the Kennedy Forum, I've been able to do a lot of health insurance appeals work with families, help draft a couple of appeals guides, serve as the coordinator for the legal task force, which you'll hear a little about from our Brian. And then finally, I continue to track a lot of the regulations impacting utilization management, which you'll hear about in appeals through a service called RedQuest. One of our co-presenters today is Mary Covington. She serves as the president of Denials Management, a healthcare advocacy firm specializing in medical billing, mental health billing, claims, and appeals. Mary's experience in healthcare spans over 45 years. She began working in the healthcare industry in 1970 and was employed by two major insurance companies through the 1980s. Mary now works primarily with families facing challenges, insurance issues related to long-term mental health claims associated with adolescent, young adult residential, and outdoor behavioral health treatment programs. So she brings a wealth of knowledge and experience to the table. In addition, we have Brian King, who has practiced law for over 20 years. Most of the time, he has represented individuals and healthcare providers litigating against health, life, disability insurers, and self-funded plans. He has been lead counsel in dozens of trials and appeals involving health, life, disability claims. Mr. King also has been the lead counsel for plaintiffs in over a dozen class actions, mostly involving ERISA cases. He's represented clients before the U.S. Supreme Court and in many federal courts and district courts across the country. He's the past president of the Utah Association for Justice. He also serves as Utah State Legislature as a representative of District 28 in the House of Representatives. Both Mary and Brian are part of the Kennedy Forum Legal Task Force, and they've mentored me on a lot of different issues related to Parity. So I'm so excited that they can join us today for this webinar. You know, part of this in terms of trying to navigate the health insurance appeals process, it's overwhelming. And as I like to say, there's 1,001 pathways in terms of how an appeal will basically take place for a given circumstance, depending on the type of insurance coverage, the type of the denial, the timing of the denial of care, and where you actually are in the appeals process. So part of today's webinar is really to provide you with some tools to help navigate that process. As part of that, I want to start off by just highlighting 3 resources, and we'll go into some more. First is the Health Insurance Appeals Guide, which Mary and my firm were able to draft and put together. And you can actually get a copy of that guide through the website there, fixmyclaim.org, which is Mary's website. A version of that guide, which really provides an overview of the appeals process, also was published by the Council for Autism Service Providers, CASP, a few months ago, which really with an autism focus. CASP also will be offering a second appeals guide, which is more of a playbook for providers. And then there's a myriad of other resources. One example, and there's a slide at the end today, which was published by the Kennedy Firm, really deals with some of the public policy issues associated with hopefully improving the appeals process over time. So let's start things off by first having Mary talk a little bit about the Health Insurance Appeals Guide, kind of the background, just give us a perspective. Mary?
Yes, thank you. Can everybody hear me? Great. All right. So, you know, the Health Insurance Appeals Guide was sort of a labor of love. It gave us the ability here at Denials Management to work with Gary and a little bit of the Kennedy Forum in putting together a guide that was going to assist families that, you know, wanted to tackle an appeal on their own. So we set about giving them enough information to let them work through that, answer some important questions, give them some step-by-step information, the different levels of appeal. So we were pretty proud of it when we were done. It took about a year to get it accomplished. So we were really proud when we got it done. So we do have it on our website, and we want families to be able to utilize it. Not everybody has, you know, enough information. You know, insurance isn't something we learn in school. So unfortunately, we kind of have to learn it trial by error, or error by trial, or whatever, trial by error. And so it's nice to have some resource for them. So thank you. I can't hear him.
Sorry, I kept myself on mute. In addition to that 70-page book, which is a must-read if you're handling appeals or want to learn more about the appeals process, there are other resources. One to highlight is parityregistry.org, which is a Kennedy Forum tool that probably has the largest registry of parity-related complaints in the country, over 2,000. But one of the things that you may find very helpful here is that it has a resource page. You hit resources, the button on the website, and then go to the specific state. It's going to list the current state regulators and federal regulators, and potentially ombudsman for the state that actually can help you file the appeal. And what you'll learn a little bit today is when you want to CC or kind of coordinate with a regulator or advocate to help you with the appeal. So take a look at that website. If you have a parity denial that you're dealing with, certainly register your complaint. I always, when I'm feeling like I want to get revitalized, I always listen to Patrick's video there on the homepage. It kind of talks about the insurance appeals process. But obviously, as part of this process is really understanding the regulatory framework as to how this all happens, since it's so technical. So Brian, why don't you kind of spend a few minutes explaining to us how this all works in terms of regulation.
Thanks, Gary. I assume everyone can hear me. Let me know if that's not true. So who is covered by what in terms of getting their health insurance? We're not really talking so much about Medicare or Medicaid today, even though that's a significant part of the population in terms of who is covered by what. That's, as you can see, probably over a third of the population is covered by one of those two things. Medicare is our population that's governed by that is an elderly population for the most part, and Medicaid is the population in this country that is on the lower end of the income scale. But most people, as you can see by the slide, are provided coverage through group plans, either a self-funded group plan that generally is provided through employment, or through a fully insured group plan, oftentimes again provided through employment, or through individual health insurance policies. Between those three things, as you can see from the slide, you've got a little bit over half the population has coverage. And it's that population that I deal with, and the folks at Denials Management Inc., Mary Covington deals with most regularly. Those are where the private insurance market is the primary player. Commercial insurers, the Blue Crosses, the United Healthcares, the Cignas, the Aetnas of the world are the big players. They're certainly not the exclusive players, but they're probably the most well-known and national players that provide health insurance or administer self-funded plans. And the body of law that applies to those kinds of plans is primarily the ERISA statute, the Employee Retirement Income Security Act of 1974. That statute applies to all employer-based plans that provide health coverage, whether it's through health insurance or through a self-funded plan, with the exception of government plans and religious organizations. So if you get your coverage through your employer, as most working Americans do, it's much more likely than not that you're going to be governed by this ERISA statute. And also the Mental Health Parity and Addiction Equity Act, which was passed originally in the 90s in its original mental health parity form, and then was made much more robust in 2008. The Mental Health Parity and Addiction Equity Act was passed in the waning weeks of the Bush administration in 2008, and it really added quite a bit in terms of a statutory and regulatory framework for requiring health plans, whether they're fully insured or self-funded, to provide coverage for mental health and substance use disorder treatment that is on a par with the coverage that's provided for analogous levels of care for medical surgical treatment. It's a complex statute. There's a lot of moving parts to it. The regulations associated with it were promulgated and made final in 2013 and made effective as of 2014 or 15, depending on when the plan year started. But we're fleshing out and developing the law in that area via case law and decisions that are coming down from courts across the country. It's a dynamic area. It is fascinating and interesting, and I think there's a lot of promise that we're going to have an extension of meaningful coverage for individuals in this country in terms of mental health and substance use disorder treatment in a positive way for consumers. But it's being sort of parsed out and decided on a case-by-case basis in the evolution of case laws that's determined across the country. And I'm really feel lucky and fortunate to be a part of that. And I appreciate so much the resources that the Kennedy Forum brings to it, that folks like Gary's group at Schooner Strategies brings to it, that folks like Mary Covington at Denials Management Inc. brings to that whole issue. And happy to share the information that we've gleaned, and that will make that job easier for everyone across the country who's advocating on behalf of families, whether it's autism, whether it's other mental health disorders, or whether it's substance use disorders. This process of making sure that we get better coverage to deal with those things is just critically important. And it's a real privilege and honor to be able to work in this area.
Great. Just a real quick question before we transition back to Mary, and Brian or Mary, you can either one can answer this. But what is the relationship between these older statutes, which I helped create at the beginning of my career for utilization management and grievance procedures that typically were adopted at the state level, and then later by the federal government, and the federal parity law and the applicable state laws in terms of a denial of care? How does that, just kind of some high touch points as to how those two regulatory frameworks interface?
Well, I can weigh in on that, Mary. You can weigh in too. But
you go right ahead.
We're talking about ERISA preemption for the most part, which is something that most people are loath to touch with a 10-foot pole. But generally speaking, it's a great question, Gary. And generally speaking, state insurance departments, departments of insurance at the state level regulate fully insured products. And as you saw from the slide that Gary just had up, most employer-based plans that provide coverage are providing them to the greatest number of not insureds, the greatest number of individuals and families are self-funded plans. Why is that important? Because all self-funded, the law applicable to all self-funded plans that are governed by ERISA preempt any state law regulation. So if you're provided coverage for your health benefits through a self-funded plan, the Department of Insurance in your state doesn't touch that plan. It can't regulate it to any degree, and they won't. I mean, if you can call a regulator, and the first question a regulator has for you, if you've got a complaint about what kind of coverage is being denied you under your plan, is to say, is this a fully insured plan or is it self-funded? And if you say it's a self-funded plan, they're going to say, we can't touch it. We don't have anything to do with it. So that's exclusive federal statute and regulation. And of course, you know, lawyers like me, private attorneys can be retained to deal with that. But we're in federal court and we're dealing with federal law, not state law. When you're talking about fully insured plans, it's a combination of regulation by state statute that deals with insurance, and by ERISA statute and regulations, and by the Mental Health Parity and Addiction Equity Act statute and regulations. So it's a mix of various regulatory and statutory schemes when you're talking about fully insured plans.
Great. And I think part of this journey is to identify what is the regulatory source for the particular coverage where you're filing the appeal. And that not only could include what Brian just referenced, but if you're a Medicare employee, or I'm sorry, a Medicare beneficiary, you know, CMS, Medicaid coverage could be a combination of CMS, Center for Medicaid, Medicare Services, and then also, for example, if you're in a state official working for a state government, that plan that's regulated probably at the state level, and for example, if you're in the military, et cetera. Mary, any comments regarding this kind of more global issue in terms of scope of coverage?
You know, I think it's really important as we get into talking about the appeals themselves. I'll be able to kind of hone in on that a little bit more for people because it's you know, the initial assessment of the case is usually where all of that plays in.
All right, well, let's have you move forward. So tell us a little bit more about the actual denial and appeals process.
Okay. Well, you know, there's several types of denials in the industry, and they're handled entirely differently. So you have medical necessity denials and coverage denials. Those are most of the ones we deal with. You do see a few administrative denials, but so first off, everyone, the first thing we do is, why did your claim deny? What was the denial reason? So that begins you on the journey of what you need to do next. If you don't know that, you need to find it out. Many insurers right now are poor at sending specific reasons for denial. Brian would tell you under ERISA, that's a requirement that you get a specific reason for denial. It shouldn't be broad. They're supposed to give you the denial reason, the page on which it's based. The denial is based. They're supposed to tell you what information you can provide in order to perfect your claim for benefits. And many of them don't do that. So that's an ERISA issue. Brian raises it in many cases, and the judges kind of goes, oh, okay. Isn't that right, Brian?
Yeah, well, we have varying levels of success about that. I think that one of the things that's been nice, you talked about the regulations, Gary. One of the things that's been nice is over time, the regulatory authority, the Department of Labor, the Department of Treasury, the Department of Health and Human Services has given more teeth to those regulations. Mary and I went back to testify before the departments. When was it, Mary? 2017 or 18, something like that.
Yeah, we've been there a couple of times.
Yeah, and the evolution of the regulatory framework has been positive in the direction of recognizing how important these things are, as Mary references. And so in that sense, it's gotten better. But the reality, as Mary alluded to, is that insurance companies oftentimes find it not in their financial interest to be particularly adherent to the regulations. The more they can leave an insured in the dark, the bottom line is the more they can leave an insured in the dark, their perception and often the reality is that it inures to their financial benefit.
Absolutely, absolutely. So once you determine whether or not your case is a medical necessity denial or a coverage denial, and I'll talk a little bit more about the coverage denials because you can have 30 or 40 different types of coverage denials. They can say it's not covered. They can say the provider doesn't meet the definition of a covered residential treatment center in the plan. They can say it's experimental. So there's many different types of denials. And so once you hone in on that, especially if it's a coverage issue, the first thing you want to do is obviously have your insurance contract in front of you, your policy, your handbook, your summary plan description booklet, your whatever the insurance calls it, a certificate of coverage. You want to get that in your hands because that is the contract on which the policy is based and what they owe you. So once you look at the denial, you go directly to your insurance policy and you investigate it. If they say it's not covered, you want to look up the exclusion section in your plan. You want to go through every exclusion. Some plans have 125 exclusions in them, and there's a lot. So you want to check it and see if what they said is true. If it's not true, then of course you're going to go, aha, I need to write an appeal. This is inappropriate. Then of course you would move on to your appeal section to see how you need to do that. For medical necessity, generally they're not using the policy. The policy has a definition of medical necessity, but that is not what they're using generally to measure the medical necessity. The insurance company or the third-party company that is doing the medical reviews for the insurance company will be using a set of clinical criteria or guidelines to drive their analysis of whether or not the services you need are indeed medically necessary. The court cases coming down are beginning to put some heat onto the insurance companies that they're not using the standard of care in the industry. And Brian will be talking about the Witt case a little bit later, but that is one thing. So medical necessity is definitely the type of denial where you're going to need to gather a lot of different evidence, and I'll talk about that a little bit later. And then of course you got administrative denials. Oh, you didn't get my premium, you know, oh, your policy's not effective. So those are kinds of things that you got to sometimes backtrack and look and see why they would say that. If you're standing there with an ID card and they're telling you you're not on the plan, get to your employer, you get to the insurance company and find out what's going on. So those are the types of denials that we're generally dealing with.
Mary,
Yes.
I want to go back to one thing that you mentioned earlier, which is you'll sometimes see these insurance companies, and you deal with this all the time in your work, because I see them in the cases that you refer down to me, but you'll deal with this blanket reason for denial of, quote, not covered, unquote. Well, that cannot stand. I mean, one of the things that you always ask, and that anybody appealing a denied claim that involves a denial basis of it's not covered, quote unquote, is to say, no. You got to tell me why it's not covered. I mean, that's just basically saying we're going to deny your claim. So almost always, I think it's wise to follow up on the initial denial basis, unless it's a very narrow and focused denial basis, and say, tell me more about why it's not covered, or tell me more about why the plan doesn't provide benefits for this service. There's always benefit in terms of pressing the insurer to give more information and detail as the regulations require in order for you to successfully be able to deny, or to appeal rather. And if they don't provide that information in litigation, it gives a much stronger argument for me to say, Your Honor, they didn't fulfill the obligations they have under ERISA to specify the denial reason.
Yes, we do. We do a lot of that. Getting the underlying basis of a not covered denial is very important, Brian. That's a good point. You know, we see it in phone calls that the pre-authorization staff had, and they'll say, oh, it's not covered, there's no 24-hour nursing, you know, and then you get the denial letter and they just say it's not covered. So you have to go sometimes back a little further to actually find the underlying basis. They can say something's not covered, but you might go on their website and find a guideline where they say, well, we think this kind of treatment is experimental, but they never said that in the denial. So looking for that underlying basis is always very important, and narrowing that down before you appeal.
And the reasons for them denying the claim under the regulations have to be provided in writing. It's not,
Yes.
I mean, you're absolutely right, Mary, that a little detective work will reveal some things, but until and unless they provide it in writing, they don't get the benefit of the specificity of the denial that you may have uncovered doing some detective work.
Well, and right now we're seeing carriers, as the pre-authorization process is unfolding, they are refusing to provide a denial letter, which is just making me insane. So then we have to go back and submit a claim, wait for them to evaluate it, wait for them to respond to the claim. And sometimes we actually have more success submitting the claim than we did on the phone call with them. So you know, I always tell families, you know, claims are sort of like a chess game. You know, you got all your pieces and you just got to start moving them. And then you make your move, and then you wait for them to make their move, and then you evaluate their move. So everything in claims in my business is about strategy. And what do you need to do? Why do you need to do it? And how do you get it done? So that is the big piece of the initial evaluation that takes place here at DMI, and I'm sure other advocates do the same, because you cannot go in blind. If you go into an appeal blind, or you start, you know, on the phone with the insurance company, you're not going to get anywhere. So you want to make sure you're doing a thorough investigation. Absolutely.
And just a quick observation. I mean, this conversation between the two of you is so fascinating. You know, based on most regulatory requirements, both the state and federal level, and for those unique programs like Medicare, and you know, if you're a military member, the health plan does have to disclose the reason for that denial. So part of I think this conversation, the takeaway is you have to document all the different communications to make sure you're showcasing the fact that you did not get the sufficient explanation. And then to add a curveball, which I'm sure, Mary, you're going to cover in a minute, they often will change the reasons for the denial. You know, in their attempt to clarify, they may switch it from a medical necessity denial to a coverage denial, or vice versa, or some other reason. So that also is important to track for purposes of due process, because by the time Brian gets it, that's just, you know, that's not appropriate to kind of keep on changing the rules on the consumer ordering provider that's trying to get the care.
Yeah, well, I could say, I always laugh and say, well, you know, the insurance companies change their denial reasons like they do their underwear. You know, that's an old joke, but it's true. We see them constantly flipping back and forth, and it makes it very difficult. And Brian will be able to attest to that in just a few minutes on, you know, what that means under ERISA, especially if they're at the final denial reason. And we find ourselves, oh gosh, you do have to change horses in midstream so often that it sometimes your head is spinning around. But the appeal processes are very important, like Gary just said, and Brian would also say that you've got to get everything in there. You are making an administrative appeal record, and that is what the lawyers need. They need that. They need a good appeal record. They need everything in there. All you're complaining about, the things they didn't do under ERISA, all of the things that they were required to do that they didn't do. So some plans have appeals and some have grievances. Some have both. So when you sit down, you got to look at the appeals section in the policy, because it can be very, very daunting sometimes. Okay, well, I've got this kind of denial, so let me find the appeal procedure that I'm supposed to be following. And so I'm always cautioning my employees. I think one yesterday looked at a prescription drug appeal process, and I go, no, that's the prescription drug appeal process. We need to be over here in the medical necessity appeal process. And so you need to make that decision. And then if there's appeals and grievances, you need to figure out well, which one am I doing? We just wrote an appeal a few months ago, and we got a response as a grievance, and we wrote a level 1 appeal, and there's 2 different processes. And in the appeal, we said, dear level 1 member appeals, and the grievance department wrote back, and I'm like, we didn't go to grievance, we went to appeals. So then we had to write a quick little letter saying, no, this was really an appeal, don't do that to us. so that's different. And then of course you have standard written appeals versus expedited phone appeals. And so expedited appeals are usually used during the process, or even you can use them if you're doing a standard written appeal, as long as the child is still, or the patient is still in treatment, which means the expedited appeal means they have to respond within 72 hours. So a standard written appeal, you have 180 days to file it. They have usually 30 or 60 days to respond. So when you send an appeal, you want to have that information available. So if they don't respond timely, you can figure out who you're going to complain to. Self-funded plan, you go to the employer human resources, you write a little memo, you attach the appeal, you talk to Sally, you say, Sally, I wrote an appeal to Aetna. They didn't respond timely. It's over 30 days. Can you please contact our company representative over at Aetna and have them get me a response? If it's a fully insured plan, individual policy, you're going to complain to the DOI. You want to send a copy of the appeal, a copy of the provision from the policy showing that they only had 30 days to respond, and please help me get a response. That usually works really well. Last week, due to COVID, we sent out 18 complaints for companies that hadn't responded to appeals timely. It's right now, due to COVID, things are very frustrating, slow. I had an insurance company that never went to the post office to pick up their appeals. Right now, their mail rooms are slow. I send 988 pieces of records. We get a denial from the appeal that there was insufficient information. The family calls me, Mary, what the heck are you doing over there? So I tell her to call the insurance and find out how many pages they have. They had 432 pages. I was like, buggers, their mailroom is not copying the appeals inappropriately. So we're running into a lot of different things due to COVID. So everybody just needs to be aware of that today. Until this emergency is over, things are going to be slow go.
Yeah. And Mary, just real quickly, I think it's perhaps if you're new to kind of this, this information could be overwhelming. So do make sure you take a look at the guide, and if you read this section, you'll kind of hear Mary's voice in the writing in terms of explaining, understanding better what the different layers of the appeals are, the types and the timelines, because most regulations and accreditation criteria do have specific timelines depending on whether the denial of care was prospective of the care being rendered or pre-authorization, concurrent while the patient is at the facility receiving the care, and retrospectively after the care has been rendered and you're trying to get reimbursement. So the states have been pretty good in terms of identifying, along with the federal government, specific timeframes, and that's actually one important hook for a consumer, patient, or ordering provider to use, as Mary notes, because a lot of times they'll not follow the timeframes, and perhaps there's a short-term kind of benefit of the doubt with COVID-19, but that's more the exception and not the norm going forward. So it's important as you kind of identify how to handle the appeals process, you're aware of that particular time frame associated with that particular appeal.
Yes, and we do have an unlimited COVID extension at the moment through the DOL for ERISA plans, and then some states, I have a 150-page document of each state's requirements for COVID. So there's a lot of stuff going on just due to COVID. But yeah, you're right. Once COVID's over, you got to go back to those strict appeal timeframes. Very important. Yeah, the consumer knowledge, I think, is one of the most issues I see. This isn't something we learned in school, obviously. I started out at Aetna in 1970, been doing this for 50 years. So I think these bullet items right here are right. About 2/3 of Americans don't know how to resolve an appeal. They don't know what department is charged with reviewing things or who they go to complain. and they don't know how to go about understanding if it's self-funded. Do they involve their employer? It can't go to the Department of Insurance. So there's a lot of that goes on. And so having advocates is I think a very important issue, or getting to information that they can glean. Google is the best thing. I love Google. I learn so much just Googling things that I'm checking. So for your state, the state insurance department websites are pretty good. I call the DOIs all the time, say, hey, I need a question answered, and they're very helpful, even to non-consumers. Filing complaints, they give you a complaint number, and so it's very good. But I would think that the more education we can do, and I think what I would like to see a push maybe some time in the near future, that we have e-appeals where we can submit an appeal through a website, because right now through web portal, it's very cumbersome. We still have to mostly send it, via mail. I always suggest sending it through USPS. We get a tracking number. When you're sending 2,000 pages of evidence, you want to make sure it gets where it's got to go and somebody signed for it, so you can use that against them later if they're saying they didn't get it all. So thanks.
Mary, tell us, what's your perspective, going back to that last slide? I have my own thoughts that I'll weigh in on about external review. You and I have talked about this a fair amount. I want to know what your thoughts are about external review and what you say to your clients who are asking you, well, it's been denied and you've done everything you can do, Mary, but they're saying I can go to external review. And isn't that...
I'm going to explain that to you. That's very important, Brian.
Please.
One of the things that we do here, everything is gauged off, how is the family sitting financially? What is going to happen if we do a standard written appeal that's going to take 60 days versus doing an expedited phone appeal? Or what's going to happen? Can the family survive not doing an external? Are they going to have to take their child out of treatment? So the family is one of the most important part of determining the strategy. So in the beginning, when we talk to them, how are you set for paying for the care while we go through this appeal process? This is going to be cumbersome. If we go through the standard written process, it's going to take months. They have to be prepared financially. And so we all know the legal strategy. The legal strategy is if you don't have to go to external review, don't do it. Now, Brian and I know that before the Affordable Care Act came out, that the only external reviews done were for fully insured plans. After the Affordable Care Act came out, we got the federal process. So that opened up a whole nother avenue. Years ago, before the insurance companies were cheating on the utilization review process, such as in WIT, we were able to get 50% overturns, easy, 40 to 50%. The insurance companies like United started cheating, making it harder to meet the clinical guidelines. So we saw that number dwindle. So as that number dwindled, and the attorneys were, yapping in my ear saying, Mary, it's not a good idea to go to external review. It made it a little bit easier for me to talk to the families and us to talk to the families and say, well, unless you're financially destitute, and you're dying, I almost prefer not to do the external review, and here's why. And so it's sort of a combination of, weighing it out with the family and the client, because they're the ones that are, suffering financially, suffering emotionally, and so I do in many cases have to leave it up to them, Brian.
Yeah, what you said is helpful, and it's in accordance with my experience and my thoughts too. What we've seen over time is the rates of reversal based on external review go like this. I mean, they go down over time. I guess for me it would be that way. But the point is, it's a function not necessarily of malice or nefarious or unethical behavior, although that may be a part of it. But I think the more innocent explanation is what we call the repeat player syndrome, and this happens in arbitration contexts too. When you have any decision maker faced with repeat players on one side of the equation and one-time players on the other side of the equation, you're going to necessarily and inevitably, it's a part of human nature, it's almost subconscious, see that the adjudicator, the judge, the arbitrator, the external reviewer is going to begin to skew their decision making in favor of the repeat players. Why? Well, because they see the Aetnas, the Cignas, the Blue Crosses, the Uniteds of the world come before them over and over and over again. They get to know these people. They get to know the executives within the company, or the claim processors, the individuals who are bringing the external review requests to them, or representing the companies on the external review requests over and over and over again. And they don't see the one-time people over and over again. So repeat players have a tendency to build up some credibility with adjudicators, or with decision makers, or with external reviewers. That's the innocent explanation, is that it's just human nature that there is over time more weight given to the repeat players. And there's an argument to be made by some that there is a financial incentive that is, an external review organization that develops a reputation, rightly or wrongly, for being overly friendly to claimants in their appeal requests, is going to run the risk that the repeat players begin to complain to the supervisors or the higher ups in the company to say, hey, we got 4 external review organizations that we deal with regularly, and got to tell you, the other rates of denial are, or rates of upholding our denials are, 80 or 90%. Your organization has a rate of upholding our denials of 55%. What's up with that? So that kind of pressure gives some insight into how the repeat player syndrome works, and why it is effective in benefiting over time, particularly the repeat players at the expense of the one-time players in a way that is adverse and hostile to consumers. So I share Mary's skepticism and concern that external reviews are really not very independent or impartial. They like, the defendants, the insurers like to refer to them as, quote, independent review organizations. I never refer to them as independent review organizations. I refer to them as external review organizations, because they're simply not independent in my experience.
Well,
So we're down to about 15 minutes, because we want to allow a few minutes for Q&A. So let's move forward. I think the point's been very well made. Mary, what are some other kind of critical takeaways in terms of filing an appeal before we kind of turn back over to Brian and talk about the legal?
Well, like we said, you got to identify the denial type, and you want, if in the beginning of your investigation, you want to document all the communications you're having with everyone. If you're calling in and you're checking up on your appeal and it's not moving, get their name, get their number, get their reference number of your phone call, so that when you do complain, you've got a history that you can write down. So that's always important. Understanding the filing requirements and timelines, as Gary talked about earlier, that is most important. I don't want everybody to get COVID lax because of this, unlimited timeframes we've currently got. So we got to make sure we're on point with that. Very important. Nothing worse than losing your appeal because it was untimely. I'll give you one example. Aetna's famous for writing a denial letter and putting one date of service, and the child's in the program for 12 months. So I can get around that denial because Aetna only wrote one date in the letter, and yet I have a whole year of treatment. So sometimes I can kind of catch the insurance companies making their own mistakes on things that actually get us in the door. So before you give up and think you're late, you want to check everything. You want to talk about the evidence. What evidence do I need to gather? If it's a coverage issue, mostly the policy, maybe licenses, regulations, things that aren't going to take a long time to get. If it's a medical necessity denial, you want to go out and get a gaggle of evidence, prior records, letters, anything you can get your hands on, police reports, emergency room records. psych testing reports, if we're dealing with mental health claims, etc. And when do you use a consumer advocate? A consumer advocate, I think, I always talk to families and I tell them, well, you don't know what you don't know. If you don't know what you don't know, you're going to get yourself into trouble. So at least get the knowledge so that you're not making a mistake. Some families will call up and do a phone appeal, and there's no evidence that goes in. And then they do another phone appeal, and no evidence goes in, and they call me, and I go, I got to think about this. So, because that wouldn't be a case that I would want to send to Brian, because there's no good administrative appeal record. So you've got to be creating that administrative appeal record in order to potentially win in litigation down the line. Health plan tricks, ambiguity. There's always ambiguity. They can say something's covered in one part of the plan, and then in another part of the plan say it's not. Of course, ambiguity is going to be different if you're looking at a ERISA plan or a self-funded plan versus a fully insured plan. Health plan tricks, you know, promising stuff that they never deliver on, you know, saying something's not covered when it clearly is covered in the policy. I find that when you talk to someone on the phone at the insurance company, I always tell families you can call them 10 times, get 10 different answers, or you can call and get the wrong answer. You know, call once and get the wrong answer. And again, it's check, check, and recheck. Getting a denial overturned, we do the happy dance over here when we get an overturn on an appeal. The chances of getting one at the level 1 or level 2 internal appeals is sometimes easy. A lot depends on the symptoms and behaviors of the person and what the medical record looks like, or, you know, if you caught them dead to rights, that it shows it's covered in the policy. I'll give you one example, a cute example. I had a claim with a family that was insured through the Bush Foundation, George W. Bush. It was the Bush Foundation. It was the George Bush signed the 2008 law, mental health parity law, and I found them with a 120-day limit in their plan. So the Bush Foundation made a parity violation. So it was funny, because when we wrote, we were like, well, you know, you were the ones who signed it into law, blah, blah. and they immediately reversed it. It was very cute. And I remember just thinking how funny it was that it was from the George Bush Foundation, and we had a family who had a QTL violation, a limitation violation, and we got that immediately overturned. So, you know when you're going to get an overturn, you know when you got a good case. Medical necessity is a little bit different, because they sometimes don't read the records, or, you know, we talked earlier, MCG criteria, interqual criteria, Cigna behavioral health criteria, all the criteria that they're writing is bad, like in WIT. So the reviewers at the external review are reviewing bad criteria. So of course they're making bad decisions, and all the criteria went bad before that started happening, and the denials or the overturns started dwindling. So as we see more legal cases come up on that, we're gonna begin to see maybe some changes. Everybody thought WIT was going to be, United was going to change their ways. Nope, they're still denying for using the wrong standard of care. So there you have it.
Well, this is very helpful. So I think that as Mary described, and she's just given us a perfect point of transition to WIT, which Brian will pick up. But I think from my perspective, as someone who provides short-term strategic guidance to families who are filing appeals, I think what Mary said is it's just so important to get the kind of the lay of the land in terms of what's the regulation, what kind of denial this is, what's kind of your rights to appeals. And I think most families have to work the phones to kind of get that information, whether you're calling the regulator or an ombudsman or an expert like Mary who works, you know, denials management or a similar firm. But at the end of the day, if it doesn't go the way that you think it should go in terms of reversing that denial, then we have to turn to Brian and his colleagues in the field in terms of who are litigating, who actually have had a very successful year. 2020 may be this kind of landmark year. There was a landmark case in 2019, which Brian's going to talk about, but the parity legal actions, there's been about 60 over the past 12 months that we've been tracking, and the vast majority of those have been positive for the plaintiff. So, Brian, why don't you give us a little background as to kind of the litigation angle of this and why WIT's so important?
Yeah, the decision, this WIT versus United Behavioral Healthcare case, is a case that really is important. It's a class action that was brought over in the Northern District of California. I was brought a long time ago, initially filed like in 2015 or so, and ended up being certified as a class action around 2017. And Chief Magistrate Judge Joseph Spiro issued an opinion in March of 2019 that outlined some reasons that he felt, in fact, United had used the wrong criteria, the medical necessity criteria, in evaluating medical necessity of inpatient care for for mental health and substance use disorder treatment. The case involved an allegation that United had basically taken language that was acceptable on its face in its policies and plans about we will cover medically necessary treatment for mental health and substance use disorders, and then developed internally medical necessity criteria that was more specific. There's nothing wrong with them doing that, but it did not line up with generally accepted standards of medical practice as was required to be provided and to be satisfied under the terms, the medical necessity terms of the plan. So Magistrate Judge Spiro ruled in 2019 and then followed up in a ruling either in November or late October, I can't remember, of this year, with an even more detailed final ruling that United Behavioral Health has now appealed, saying there was a violation of generally accepted standards of medical practice by United in the use of its medical necessity criteria. Critically important, there are two separate things that are very much related but have to be kept separate in mind. In this particular case, what you had is Judge Spiro saying, the criteria that you were utilizing is on its face problematic. And that sometimes happens, that you have the criteria as written by an insurer or plan administrator be inconsistent on its face with generally accepted standards of medical practice that the terms of the plan itself require be utilized in evaluating medical necessity. A variation on that theme, however, and that I see quite frequently, and so does Mary out at Denials Management, Inc., is that both the language of the plan saying we cover medically necessary treatment, and the criteria itself is fine. We look at the criteria and we say, okay, we can live with that. But the way in which the insurer has interpreted the criteria and has applied it to the facts of the specific case is wrong. So what I'm getting at is the distinction between medical necessity criteria that on its face is a problem in terms of generally accepted standards of medical practice, or for a mental health parity analysis, the analysis that you'd carry out there, versus facially neutral or acceptable medical necessity criteria that as applied violates the terms of the plan or violates the requirements of the mental health parity statute. So to get into the details of the WIT ruling from Magistrate Judge Spiro, this slide outlines those things, that you have to look at the individual's underlying conditions and not just limit the coverage to alleviation of current syndromes, number one. That number two, you have to look at co-occurring or comorbid circumstances in terms of the child's or the individual's conditions. Sometimes you have insurers who say, we're going to look at whether the symptoms of the individual's bipolar diagnosis are so severe that it requires inpatient care. Well, in fact, you may have a child or an individual who's been diagnosed with both bipolar disorder and with some substance use disorder. If you don't take into account both diagnoses and the degree to which they aggravate each other, or they need to be treated together and need more intensive care, that's a violation of generally accepted standards of care. The next one is safe and effective threshold requirements, that patients have to receive treatment at the least intensive and restrictive level of care that is both safe and effective. So you see sometimes insurers, and United did this in WIT, that they would say this is safe to be treated at a lower level of care. Magistrate Judge Spiro said yes, but it has to be both safe and effective. If it's not effective, if it's only safe, That's not in alignment with generally accepted standards of care. Erring on the side of caution. Don't expose the patient to risk of self-harm or lack of safety that's required if there's a doubt there. In other words, you give the benefit of the doubt to the requirement of and to the recommendation of care by the treating physician. The next one, maintaining function or preventing deterioration. Effective treatment protocols require that you have to maintain function or prevent deterioration sometime. Even for an individual who may be stable, they still may need ongoing care at the level of care that's being requested to maintain functioning or prevent deterioration. That there are no default time limits. We've seen, Mary and I have seen a lot of insurers say, hey, look, the average length of stay from our perspective is 4 weeks in a residential treatment setting, when in fact the average length of stay across the industry, across the medical spectrum and the mental health care and substance use disorder treatment spectrum for residential treatment is more like 7 to 12 months. So you can't have some artificially small or short limitation of time frames that are applied on a cookie cutter basis by an insurance company pass muster when you're evaluating medical necessity. Next to last, factoring the needs of young patients. Many of our clients, my clients, many of the patients and clients that Mary deals with are in fact adolescents being treated at a subacute inpatient level of care. They have different needs than adults being treated for mental health disorders or substance use disorders on a subacute inpatient basis. And then finally, the need for multidimensional assessment requires the appropriate level of care for patients should be made based on a multidimensional assessment that considers all the information, a wide variety of information about the patient. In other words, these are very fact-sensitive and case-sensitive circumstances. And to some extent, there has to be deferral to the deference exercised by non-examining and non-treating clinicians to the recommendations for care that are made by treating clinicians who have had an opportunity to examine and interview the patient, and based on that unique perspective and that invaluable source of information, make recommendations that are valid in terms of what the appropriate treatment plan is. So that's a critical thing. In terms of filing a legal action, best to find an attorney who knows what they're doing. And quite honestly, there aren't a ton of attorneys across the country who regularly deal with this in this area. I can probably count on hands and feet the number of people that I would trust across the country who have experience in dealing with these things. I think that will increase over time, but it's a complex area of law and it takes a lot of expertise. You have to exhaust internal appeals. The worst thing that it's committing legal malpractice for an attorney to get a case that comes into their office and then go straight to court. You've got to exhaust these internal administrative appeals, or pre-litigation appeals, I like to call them, because they're not administrative law. They're pre-litigation appeals, but they're essential as a prerequisite to bringing suit. Generally, these cases are brought in federal court if they're dealt with either ERISA or the MAPIA, the Mental Health Parity statute, and they are initiated by filing litigation in federal court. I do that on a day in and day out basis. The elements of the legal action are that we gather as much information. As Mary said earlier, if it's not in the pre-litigation appeal record, if the claim hasn't been set up properly, I oftentimes will just say to people, I can't take it on a contingent fee basis at least. It's just not a valid claim that I can get anywhere with. That pre-litigation appeal process is absolutely essential. We try and settle most of these cases, and most of the time we can settle them if they're well pled and if they have a valid, good, strong pre-litigation appeal record put together. Most of the cases that I take to be ruled on the merits, I have varying levels of success for a variety of reasons that I can't get into now based on the lack of time. But I will say that ERISA does allow for an award of prejudgment interest and attorney fees to successful plaintiffs in the court's discretion. I've had some courts say, you know what, I think this denial was wrong. I think it was an abuse of discretion. It was arbitrary and capricious, and I'm reversing it. And I'm going to order payment of the benefits. But Mr. King, it was a close call, and so I'm not going to award you your attorney fees. Makes me crazy, but it doesn't happen most of the time. Most of the time I do get an award of attorney fees when I prevail, but it's within the court's discretion and it's not a guaranteed automatic thing to a prevailing party. So those are the key steps on filing legal action. I don't know if there's another slide, Gary, or whether you just want to go straight to questions.
There's one more slide, which is more public policy slide, and then we'll take a couple questions. I think as you think about this from a public policy perspective, the Kennedy Forum issued a brief on ways to improve and how to file a health insurance parity appeal is a worthwhile document to review. We don't have time to go into it, but if you type in the title of that issue brief, which is on the first slide, and then Kennedy Forum, you'll find it. But part of what you've heard today is really the lack of standardization in the appeals process. And I think that as part of this, we need to work together to really kind of improve how the health insurance appeals process works. The appeals process is a quarter-century old, I like to point out, from my early days at the NAIC, and the external review process is now 15 years old. And we certainly heard criticism about both of those appeals processes. So I think there's an opportunity to work with our state and federal regulators and other public policy makers to update the standards of care. And just kind of one point of inflection, traditional utilization management or traditional denial of care is short-sighted. There's plenty of kind of data analytic and population health models that show that if you actually treat the patient for their comorbidities, as we mentioned out before, which is part of the generally accepted standards of care, it's actually, there's both benefits in terms of financial and clinical outcomes as treating that patient or the target population in a more holistic way and in a more proactive manner. So therefore, this whole kind of traditional denial appeal system is not really a cost-effective strategy for the health plan who's trying to save money, and also, quite frankly, the populations that they serve. Now, reminded back in the early 2000s, United made kind of a pitch that they're doing away with utilization management. And of course, that predates the Affordable Care Act and Parity. But there really has been a regression to kind of this traditional denial of care, so it's related to mental health and addiction services. And I think that we as a society decided in 2008, certainly perhaps before that too, but when we adopted the federal parity law, that we really we want to treat the brain, mental health, addiction issues, just like we treat the rest of the physical body. So obviously we need to have a lot more time to share with you guys different elements of this. But let me, instead of taking questions, why don't I turn it back to, since we're about a minute over, Mary and Brian, if you just want to say one kind of final thing in terms of wrapping up, and perhaps we'll do some additional webinars, but I'm sure the information I know has been very helpful. So Mary, why don't we start with you? Any kind of final observations, recommendations, feedback?
Well, I think it's great to be able to share what we know, with people that just don't deal with it on a day-to-day basis. And I'm excited that, we're getting a new administration that, is going to maybe do some better good for what we need to get done with mental health parity. And the WIT case was the beginning, and I just think it's going to go on. Brian's going to keep settling cases. I'm hoping for those mental health parity wins. That's what I'm waiting for. And we're also working on wilderness claims and getting them also moved into the right realm for coverage. So, but I do appreciate everyone's time. Thank you so much.
Right. Brian, any final words of wisdom?
The only thing I would say is how critically important this is. And the Kennedy Forum has been wonderful. There have been a lot of people, a lot of organizations have been moving the ball down the field in a positive direction for this area of work, but we have to keep at it. The welfare of people in terms of their mental health conditions and addressing effectively their problems and their substance use disorder problems is something that is of paramount importance across this country. And I'm privileged to be a part of it. I appreciate so much the work of the Kennedy Forum and so many others. Autism Speaks is an organization that does tremendous, wonderful work. Covington, thank you, Mary. I have many colleagues in litigation who are doing great work. We just need to keep it up. We're making progress. Good things are happening. I continue to believe that we're going to see great things happen in this area as we move forward.
Right. Well, Mary, Brian, thank you so much for participating in today's webinar, but most importantly for your body of work, your mission, how you're effectuating change. It's been an honor to work with you guys and learn from you. On this last PowerPoint, I have contact information. These guys are the types that will return your call and talk to you. to give you general advice and counsel, as I will as well, please feel free to reach out to us. Again, a copy of this webinar today and the PowerPoint slides will be sent out via a link for all those who attended. We look forward to maintaining the dialogue and hopefully effectuating some meaningful change to basically make sure that there is equity when it comes to mental health and addiction coverage. Thanks again, and that will wrap up today's webinar. Take care.
Thank you.
All right, bye-bye.